A Rasmussen or contested omnibus hearing is the same thing, they're just different labels. A Rasmussen hearing is for misdemeanor cases, and a gross misdemeanor and felony case have a contested omnibus hearing. But the purpose for either one of them is the same thing. One, to suppress evidence, which means to throw evidence out of a case, and second, to get charges thrown out of a case, or maybe even your whole case thrown out. And the types of things that come up in Rasmussen or contested omnibus hearings are whether or not any of your constitutional rights were violated by law enforcement. Those are things like whether or not the officer had a right to pull you over if you're driving a car, or whether the officer had a right to order you to stop if you're walking down the sidewalk, or start to question you in your home, to search your home or your body or any of your personal belongings, or search your vehicle, whether or not they had a right to question you and whether they violated your Miranda rights or not, whether there was probable cause for the charges against you, and things like that. So those are the things that are typically attacked by the defense at a Rasmussen or contested omnibus hearing. And in order to do that, we have to file what's called a suppression motion and ask for a Rasmussen or contested omnibus hearing. And we have to do that before the trial date, and each county kind of has their own rules about when those things have to be filed. But procedurally in your court case, first you have your first appearance in a case, and then usually what's called a pre-trial, and then after that you can ask for a Rasmussen or contested omnibus hearing, and those are done prior to the trial in a case. And so to do that, we have to file a notice of motion to suppress and dismiss in a case and tell the court what we're attacking. For example, we believe that our client's Fourth Amendment rights were violated because law enforcement didn't have a reasonable, articulable suspicion in order to pull a vehicle over. Or law enforcement didn't have a right to search the home without a search warrant, or law enforcement didn't have the right to question our client without reading Miranda first, or law enforcement didn't have a right to search the trunk in a vehicle or a backpack or a storage unit or things like that. So those are the common types of challenges that come up in Rasmussen or contested omnibus hearings. When you get to that Rasmussen or contested omnibus hearing, we have a right to cross-examine the officers that were involved in your case. So the hearing is before a judge. You don't have a right to a jury at that point because it's not the trial yet. And we have a right to cross-examine any law enforcement that takes the stand. We also have a right to subpoena anybody else to come and testify that would help your omnibus or contested Rasmussen hearing challenges. And you have a right to testify if you're a defendant in that case, or you can remain silent. If you testify, that testimony cannot later be used against you at trial, unless, of course, you testify differently at trial and you do what's called impeach yourself at that point. So the purpose of that hearing is for a judge to hear and decide whether or not any of your constitutional rights were violated by law enforcement, and if so, whether that means some evidence is kicked out, or whether potentially some or all of your charges should be thrown out. And after a judge hears the testimony in a case, then usually a judge will have us lawyers do what's called brief it, which means write written arguments about what the facts are, how those facts apply to the law, and why your charges or evidence should be thrown out. And the prosecutor will do the opposite and argue that the charges should stay in and that the evidence should stay in. And then a judge will write what's called a written order after that in most cases like this, and they'll make a decision about whether or not evidence should be suppressed or thrown out in your case, and whether charges should be thrown out or not. In this case, we contested, for example, whether or not law enforcement had, or the prosecution had probable cause to continue with their charges against our client. And after a contested hearing, the judge wrote that indeed law enforcement did not have probable cause to go forward with the charges, and this entire case was dismissed after a contested omnibus hearing. So that's the way a Rasmussen or contested omnibus hearing works. They're very beneficial in cases where you have a challenge. You don't always have a right to have one. If none of your rights were violated or not even potentially violated, then you can't get a hearing like that. You've got to have some cognizable claim as to why your constitutional rights were violated or why certain evidence should be suppressed in your case. If so, then you got to get it in writing, filed with the court in advance, and make sure you get that hearing. The advantage to doing it is that your evidence could be thrown out or your charges could be dismissed. Or sometimes even if you don't win the hearing, there's still a collateral benefit, and that is that you got a sort of a sneak peek or advanced peek at the prosecution's case, and you can determine how much exposure you have and whether or not you should go to trial in a case. So there are many benefits. Those are just a couple to having a contested omnibus or Rasmussen hearing. If you have more questions, my name's attorney Ryan Pacyga. You can find me at arrestedminnesota.com.